So yes, there are at least thousands of students affected. I would say it's in the thousands. It's not in the hundreds. We were not sure previously as to what the number is, but now we know that it is at least in the thousands. We don't know how many thousands. And CVIS has not published that information. But generally, what's happening is that students are receiving an email from the Department of State, basically stating that their visa has been revoked. And basically, what's happening is Department of State is saying that pursuant to an email sent earlier, we're writing about an important and serious matter in reference to your non-immigrant status, they're saying. And then they're saying that the Bureau of Consular Affairs Visa Office has alerted the Department of Homeland Security, Immigration and Customs Enforcement, that's ICE, which manages the student exchange visa program, blah, blah, blah. And they're saying that not only are we revoking your visa, but we've also informed ICE that the visa has been revoked. And then Department of State is going on to advise students that remaining in the US without any lawful immigrant status can result in detention, fines, deportation. You may not be eligible for any future visas. And they're also saying that deportation can take place at any time, and it won't allow you, the person being deported, to secure your possessions or conclude your affairs in the US. And very importantly, persons being deported may be sent to countries other than their country of origin. So you see how they're spreading fear among students, basically asking them to self-deport. They're also sending a link to the CBP Home app, where they can voluntarily, it's called voluntary departure. It's an old concept, it's not a new concept, but where they can voluntarily depart so that they're not put into removal proceedings. So in addition to that, then people are also receiving emails from CVIS saying that your CVIS has been terminated. And that they're saying you have 15 days after the end date of your CVIS to, change. Otherwise, after that, it'll get locked. So within those 15 days, I'm presuming that you will not be able to make any further changes to your CVIS. And that this is coming from the Student and Exchange Visa Program. So that's what's happening. They're getting Department of State emails, and they're getting CVIS termination emails. And the CVIS termination emails are talking about, foreign policy concerns, and vague. There's no real reasons being given. They're just saying that you have not maintained your status, and they're not saying why you have not maintained your status. So I think it's minor past arrests, even dismissed charges, any online activity that's deemed suspicious. I think this is all causing CVIS termination. And mind you, this is not standard enforcement from CVIS. I think it reflects a broader and more aggressive scrutiny and what they call extreme vetting from the Trump administration. And CVIS termination results in an immediate loss of status. So this is really ripe for litigation, because before you lose your status, or before you're you're asked to leave, you should be given some opportunity to to address it. So, and that's not happening. So a lot of students are getting scared and are just leaving, even though they haven't completed their degrees. Yes, because they have no choice in many instances. They have to leave because the school is saying that you can't graduate. Or sometimes they have exams that they have to attend in a few weeks, and the school is saying that you cannot write your exams. So they're being forced to, and I'm hoping that some schools will push back. I'm hoping that they will at least allow them to complete their degree before they have to leave, because it's the end of the year. Well, usually it could be like a speeding ticket, but not like a speeding ticket, just a regular speeding ticket. But if it is, if the person is arrested for a crime, meaning that there's a speeding ticket and then something happens as a result of that, such as reckless driving, that's a criminal offense. So it could be for that. It could be for reckless driving itself. There could be a DUI or a DWI, which is driving under the influence. If they've been caught, and if their alcohol levels are above a certain percentage, then it's called a DWI or a DUI. In some instances, there was a student who didn't even get a DUI, for example, but he got less than a DUI, meaning that it didn't meet the standards of a DUI, but he was still arrested. Driving while, it's called something in New York, I don't remember. But even in those instances, people are getting caught. It's called, I think, driving while ability impaired. It's called a DWAI. It doesn't meet the DUI, so it's not, the alcohol level is not that much, but they're still under that statute. They're, at least in New York, I've heard that they're arresting people. So that could just mean one drink. Yeah, and I was going to talk about that. The third factor is shoplifting, and shoplifting is by far the most common reason that students get arrested, and oftentimes it does not result in a conviction. They are let go by the judge. There's no misdemeanor. Sometimes there's a misdemeanor. Sometimes they let go without anything. And in all these instances, students, their status is being terminated. And oftentimes the shoplifting cases are incorrect, meaning that there is a mistake on their part. They buy 5 things and there's another thing in the bag which they forget to bring up or something like that, and they walk out and then the alarm goes off. And in these instances, often the judge just lets them go because they believe their story. So even in those instances, since they've been arrested, even though they were not charged, they're automatically coming under the CBIS, under their ICE radar, and they're just canceling their CBISs without even looking into what the charges are and whether they've been convicted or not. It just seems to be that they've received intimation from the higher ups that anybody who has any kind of problems, whether they were convicted or not, they should just have their CBISs should be cancelled. And the officers also, the ICE officers also are getting blanket instructions that anybody who didn't leave should be put into removal proceedings and should be detained. Even if they have a reinstatement filed, even if they have a change of status application maybe pending, and even if they've going to court, even if they have litigation pending. So one of the reasons is, of course, Lalit, as I said, something to do with some kind of a criminal arrest. But also there's another reason. It could be non-criminal violations, such as immigration violations, unauthorized work, maybe lying to USCIS officer, providing fake documentation, overstaying of their visas. These are, of course, serious offenses, but they're also offenses such as, the CBIS getting terminated by mistake due to some administrative error. I've heard so many cases like that. People who called me saying that it got corrected, there was some administrative error, but now they're getting CBIS terminations several years later. There was another student who started working on campus and started working for the university, summer job. University said it was fine to work, applied for Social Security, and they said that once we get the Social Security, we'll put you on the payroll, but you can start working in the meantime. She followed their instructions, and now she has a CBIS termination. Another case in which a person upstate New York, there was heavy snow, he got into an accident, called the cops because he was hurt, and instead of helping him because he's a victim, they actually arrested him. And he has a CBIS termination. There's so many stories. And it's not like none of them are felons, that's for sure. So these are the stories that I'm hearing. I think mostly with Indian students, I'm seeing that it's not so much social act. Again, we don't know because they're not actually giving us a reason. Uh, it could be for people who don't have any other reason. It could be social media. They can't find any other reason. But most of the students have had some kind of an issue, and they're able to identify the issue. Even though they're innocent, they still think that it was because of a particular issue. With reference to social media, now I must tell you, not just students. I think yesterday we got an email from USCIS saying for any kind of benefit that is being issued by USCIS, they're going to be checking social media. So they have said it outright. They're not doing it on the sly anymore. Citizenship interviews, adjustment of status interviews, visa consulate interviews. When you enter at CBP, of course, they've always been checking your social media when you enter the country. But now, even when you're filing for a H1, filing for, say, work authorization, or you're filing for advance parole, whatever you file for, they want to check your social media handle. And that's one of the reasons where, there are many reasons, and they're saying that it will be taken, the full picture will be taken, and not just that. But it's scary because they can use that as a single reason to deny any kind of benefit. With reference to the options, of course you can file for reinstatement. You have to do this, of course, only after the DSO recommends it. So that DSO has to recommend it by giving a letter, and they have to give you a new I-20, a reinstatement I-20. So using that reinstatement I-20, there are two options. You can either file for reinstatement, or you can leave the country and file for a new visa. Now, leaving the country and getting a new visa doesn't seem to be like an option to me, because they're unlikely to give you a new visa. Now, talking about reinstatement, the problem with reinstatement is, again, we don't know whether finally they will agree to reinstate. Maybe in those instances where there was no conviction, they might agree to reinstate, but we're very skeptical about it, considering the present administration and the fact that they're not very sympathetic towards non-immigrants. And the other problem with reinstatement is that it can take 6+ months for reinstatement. And while the reinstatement is pending, ICE can still come and pick you up, and they've said so, that they don't care about even if you have a reinstatement case pending. So the student is still not safe, even if they're filed for a reinstatement case. And the other problem is the problem of unlawful presence. Unlawful presence is a law whereby, if you stay out of status for more than 6 months, and if you leave and try to come back, then you'll be barred for 3 to 10 years from coming back into the country. And while unlawful presence is not supposed to apply to students, USCIS has recently on their website, last year, in fact, in September of 2024, has said that unlawful presence applies to students as well. While this is not the law, because just publishing it on a website cannot be the law, we're worried now that they might start interpreting unlawful presence in this way and, say that students are unlawfully present and then put a bar on them. So that's what we're worried about. So we are advising students to keep that in mind and not stay for too long, even if they don't get the reinstatement response. So reinstatement is one option. Second option is, of course, for those students who have not yet gotten a STVIS termination, but for those students who know that they have got into some kind of trouble in the past, even if they have not been convicted or are worried about their status, I would say change your status before you get STVIS termination. But first check your STVIS to make sure that it's not terminated already, because a lot of students have not received an email. They've just checked their STVIS and found out that their STVIS has been terminated. So be aware of that as well. So change status if you can. Litigate. If your STVIS is already terminated, I think litigation is the best option. There are many attorneys who are filing class action lawsuits, and these lawsuits will allow many students to join in one lawsuit, and this will be economical for the students as well. And usually the attorneys that do the class action lawsuits will present the best case. They'll use the best case as an example. So many students who don't have that good a case can also benefit from that best case scenario. So class action lawsuits are definitely a good option. And the good thing is, if the judge orders a temporary stay on removal, then ICE officers might not try and remove you or detain you. Again, who knows? Because we know that that's happened as well in the past. So litigation, reinstatement, change of status wherever you can change your status, leaving and trying to re-enter on a different status. These are the options that you presently have. And of course, last but not the least is voluntary departure. Leaving on your own accord is also an option. So and then try to come back on a H1, or maybe get another F1 visa. That's also an option. So this is fairly new, and it's still evolving. The whole process. I think CBIS terminations, we started getting them only last Thursday, or last Wednesday, so it's only about a week old. And they have not yet, as far as I know, started the enforcement process of, doing removal. So expedited removal is something that they want to do. Even for expedited removal, they have to issue an NTA. There's a process involved. They have to issue a notice to appear. But the thing about expedited removal is that you don't necessarily have to go before a judge. But you can ask to go before a judge and be put in removal proceedings before a judge, but then you will be detained, and a lot of students don't want that. So that's the problem, and that's the catch-22 situation that the students are facing. One side is trying to fighting for their rights, and the other side is detention, worrying about detention. So neither option is good at this point. I think, and I hope that the administration don't see students as illegal immigrants, because they're not. They're legal immigrants. They're spending a lot of money improving the economy of the United States. Most universities run because of foreign students, and the revenues that foreign students bring are in the billions, literally. So targeting foreign students will only be problematic for the US economy, because they'll lose all these students to Canada. Canada is already advertising, Canadian universities are already advertising, come to Canada, we're a country, we're open to foreign students, we are a country of rights, and we are fair to our immigrants, etc., etc. So they're making use of the situation already.